So this set of videos is about the American judiciary, mostly the Supreme Court. The Supreme Court I call here mysterious. And the reason I say the Supreme Court is mysterious is because it is the least public of all of the three branches of government. They operate usually behind closed doors. The only thing that the public really gets to see in terms of the court's real workings is the oral arguments, and that the public doesn't get to actually view, they get to hear. Audio recordings are released. And so the Supreme Court is essentially the most mysterious branch to most people. The justices are appointed for life, and they're not elected. It's a very different sort of world than we typically think of. You have 9 justices in the Supreme Court. It doesn't say that that's the number you should have in the Constitution. The Constitution doesn't say much about what the Supreme Court should look like. It just says they'll be led by the Chief Justice, and then we have now 8 other justices in addition to the Chief Justice. So let's talk about a little bit of background. Considering that there are, remember this is a federal system, so there's some state laws and there's some federal laws. For the Supreme Court to hear your case, there needs to be a question of a federal law. The Supreme Court does not hear cases that are only involving a state law. We could also divide cases between criminal and civil, right? A criminal case is that you've broken the law in some way, and the government has charged you with a crime. In civil cases, you're suing somebody and asking for some sort of justice to restore, the harm that they've made to you. In general, for both criminal and civil cases, most cases don't go to a trial. That they're settled outside the courtroom, either with some sort of like a plea deal in a criminal case. I will offer you information on other crimes if you let me go. Now, specifically when we talk about the Supreme Court, we also have to make another distinction. When the Supreme Court decides a case, right, they vote on who should win. That's a question of the votes on the merits. Between the two sides at the case, when it gets to the Supreme Court, the Supreme Court votes on who should win. They also then issue an opinion. And the opinion is why that side won. And this is very important because this distinction, because why that side won, when the Supreme Court writes that, it is telling all lower courts, this is how you should decide other cases. Okay? A vote on the merit is just about that particular case and that particular set of facts. The court, in the opinion, is going to talk more broadly. And then they're dealing with things that you would call maybe common law, which is essentially the interpretation of the law by courts, and most importantly, precedent. And with precedent, what we mean is that if a case is decided one way, future cases should be decided in a similar manner. Okay? And so that's what we get with precedent. Right, the idea that when the Supreme Court writes an opinion, okay, saying that this is how we decided this case, this is why this side won, and then that applies to future cases, that means that you're applying the precedent of this case to the future cases. Okay, this is essentially how the federal judiciary is designed, but including state courts. Now you'll notice, right, the Supreme Court, U.S. Supreme Court at the top in the middle, and the state Supreme Court on the left, these are what are known as appellate courts. That is, these courts do not hear the first cases. That's not where cases start, generally. Cases generally start at lower courts, and if you lose, you can appeal up, right? So you can start in a state trial court, that's the left-hand side, debating a question of state law, and it goes up. If you lose there, you can appeal to the state intermediate court. They're called different things in different states. And then that can be appealed to the state Supreme Court. Now, the state Supreme Court doesn't have to hear the case. Okay, the state intermediate court does have to hear the appeal. The state Supreme Court can just say, we're not going to listen to this. Whatever happened at the intermediate court holds. And you can do the same thing on the federal side. Right, you can start at the district court, appeal to a three judge panel at the U.S. Court of Appeals, and then if you lose there, you have two choices. You can decide, okay, I want to be heard by the Supreme Court, or maybe I want to be heard by the U.S. Court of Appeals en banc. That means the entire U.S. Court of Appeals, not just a three-judge panel. Now, in all those cases, the state Supreme Court, U.S. Supreme Court, and the U.S. Court of Appeals en banc, all those cases are, as it says, appeal with discretionary review. The courts do not have to hear those cases. They can just let the lower court ruling stand. You'll also notice that there is a line from state Supreme Court to U.S. Supreme Court. In order to challenge a case that you lost at the state Supreme Court level to the U.S. Supreme Court level, you have to explain what's the federal law that's in question here, and not just the state Supreme Court law. Let's talk about the history of the court for a little bit. Remember, it doesn't say much in the Constitution about the Supreme Court. It just says that there's going to be a court. It doesn't give the Supreme Court any powers. It gives Congress the power to decide what the courts are going to be like. So early on, the court didn't have much prestige. Now, that changes about by the third presidency, or the presidency of Thomas Jefferson. And it's wrapped around this thing called that dealt with John Adams' midnight appointments. John Adams was the second president of the United States. John Adams was a Federalist. And when he lost his bid for re-election, he appointed people to different positions, including a new Chief Justice, John Marshall, including a Justice of the Peace, William Marbury. William Marbury is not that important. Historically, Chief Justice John Marshall is very important. But what's important here is that Adams is a member of the Federalist Party, Marshall's a member of the Federalist Party, and Marbury is a member of the Federalist Party. Okay, and the Federalist Party is leaving the White House. They're losing control of Congress. The Jeffersonian Republicans are coming in, and Jefferson orders his Secretary of State, James Madison, to ignore the appointment of William Marbury. And Marbury sues James Madison. And this leads to this famous case, Marbury versus Madison. And there's a video that I've linked to here that you should watch to learn more about that case. You really need to watch that to understand it. But the basic idea is that Marbury is saying, you should appoint me to this position, and you're only denying me because of my party. And Chief Justice John Marshall, the Federalist, says that actually the Jeffersonian Republicans win the case. Marbury, he rules against his own partisan. Okay, but what he says is important. He says Marbury shouldn't be appointed because the law that would lead to Marbury being appointed is unconstitutional. Okay, which means that this is really the first time the Supreme Court has overturned a congressional law. Okay, and this means that it is the first instance of the Supreme Court using the power of judicial review. The most powerful power, the most powerful check on Congress and the presidency that the Supreme Court has, that is not mentioned in the Constitution. Judicial review, the power of the courts to rule laws passed by Congress and signed by the president as unconstitutional. Okay? And really what Chief Justice John Marshall is doing here is he's saying the people from my party lose this case, and the reason they lose this case is because the Supreme Court, the only branch the Federalist Party still holds, is the most powerful branch in terms of having the final say on whether or not a law can stand. Right? And so this is where the Supreme Court gets so much power, through this idea of judicial review.